you how you view the role of Solicitor General. Many times you as Solicitor General may not personally agree with a particular statute, yet you must enforce and defend these laws regardless of your personal views, and I believe you must do so vigorously. And I don't have any doubt that you would do that, because it's your duty. You do not get to pick and choose which statutes to defend. If confirmed, would you vigorously enforce and defend the laws and the Constitution of the United States? And I believe you quite obviously said you would.
Yes, I certainly will.
Okay. The President opposes the Defense of Marriage Act. Recently, the Department of Justice announced that it would no longer defend the act. I understand that you were recused and that recusal ended a couple weeks ago from internal discussions on this issue based on work performed by your prior law firm. If you had been involved in the discussions and advising the President, would you have told him that the administration must defend the statute?
Senator, I think that having been recused, I really didn't play any role in thinking about the question of how to apply the traditional standards of reasonable argument and defense to this situation. I've read the letter that the Attorney General sent to the Congress pursuant to 28 U.S.C. Section 530D. I've read the Attorney General's statement. Beyond that, I really don't have any developed sense about the legal analysis or issues. But what I can say about it is that I worked at the Justice Department for a year and worked with the Attorney General. And I've worked now for a little more than a year at the White House for the President. And based on that experience, I have a great deal of confidence, certainty really, that each of them understood the gravity of this decision, each of them understood the difficulty of the issue, and each of them undertook to make a decision based on the law. Beyond that, I don't really think I can say more.
If you're confirmed, you'll be Solicitor General of the United States of America. Your client will no longer be the President if the President believes a statute should not be defended, but you believe there is a basis on which it is defended. Would you vigorously defend it?
Senator, I would certainly, if I believed that there was a basis for defending a statute, that would be the judgment I would make, that it ought to be defended. And I would, to the extent the President inquired, I would certainly provide the President with that advice.
Does that include the Defense of Marriage Act?
Well, Senator, the President has made a decision about the Defense of Marriage Act, and the Attorney General has made a decision about the Defense of Marriage Act.
Well, then I think you answered this question just now, but let me ask it anyway. If the Attorney General concluded that a statute should not be defended, but you disagreed, what would you do?
Well, I'd give my best advice to the Attorney General. Ultimately, the Solicitor General is exercising authority that's given by statute to the Attorney General and delegated by regulation to the Solicitor General, so it is the Attorney General's authority, but I would, in all instances, give my best advice.
Yeah. Section 2 of the Defense of Marriage Act permits states to choose whether or not to recognize same-sex marriages from other states. Do you believe that this is a valid exercise of Congress's power, and would you defend Section 2 of the Act if it's challenged in the Supreme Court?
Senator, because I've been recused, I haven't given any specific consideration to that issue, but I can pledge to you that I would apply the appropriate and traditional standards for deciding on defense of a statute in answering that question.
Well, I guess to clarify then, would you defend the Defense of Marriage Act as Solicitor General?
I think the best I can say to you, Senator, is that I would, in good faith, apply the traditional Justice Department standards to answering that question to the extent it hasn't already been decided by the President and the Attorney General.
You told the previous questioner, the distinguished acting chairman, that there was only 2 exceptions. And I don't see how the question I asked falls into either one of those exceptions, but I'll leave it go at that. Thank you very much, Mr. Chairman.
Thank you, Senator Grassley. Chairman Leahy. Thank you, Mr. Chairman. Let me just follow up a little bit of that on DOMA. I read Attorney General Holder's detailed letter to the President, and he said he made his decision based on the legal analyses of the Justice Department, not his policy preferences. He determined that the courts apply heightened scrutiny to DOMA, a standard the department is urging should apply because DOMA treats people differently based on their sexual preference. The law wouldn't pass muster under the Equal Protection Clause of the Fifth Amendment. And it said that because of that, the administration couldn't make a reasonable argument in the court that it was constitutional. Now, this is not really that different than any other administration. I know that past administrations, Republican and Democratic, have done the same thing. One example I brought out was in 1990, President George H.W. Bush's acting Solicitor General did not defend an FCC policy, adopted at the urging of Congress, aimed at increasing minority ownership of radio and television stations, even though the FCC chairman had asked the Bush administration to defend it. In fact, he submitted a brief to the Supreme Court arguing that the FCC policy violated the equal protection component of the Fifth Amendment, argument the laws, 5-4. That was that Solicitor General was John Roberts, who's now the Chief Justice of the Supreme Court. Do you have any problem then, if you're a Solicitor General, to defend the constitutionality of duly enacted statutes if reasonable constitutional arguments can be made?
I understand that is the responsibility of the Solicitor General. Yes, Mr. Chairman.
Thank you. I also want to commend you on the significant work you've done to provide Sixth Amendment, or to protect the Sixth Amendment's right to effective counsel. I worry that too often an individual's right to effective counsel depends on how much money they might have. And I've asked a number of nominees about one particular precedent, Gideon versus Wainwright. It moved me a great deal. As a young law student, I had an opportunity to sit at lunch with Justice Hugo Black shortly after he authored Gideon. He said he recognized, of course, the Sixth Amendment's guarantee to counsel, fundamental right, and so on. That wonderful book, Gideon's Trumpet, I recall reading that. But doesn't Gideon stand for the principle that to be meaningful, such a fundamental right as a right to counsel requires assurances it can be exercised? Not just that it's there, but it has to be exercised. I'm thinking particularly in capital cases.
Yes, Senator, I think it does.
Okay, and we're trying to pass legislation to ensure that they are, that there is effective counsel. Now, because of your work there, some say you question whether you can defend the government's position in a capital punishment case where they're seeking capital punishment. How do you feel about that?
I understand that, Senator. There is a federal death penalty law. It is enforced in appropriate cases. And if I were confirmed as Solicitor General, I would certainly and vigorously defend the application of federal death penalty law.
Thank you. And Ms. Seitz, good to have you here. I did not know your father. I have great admiration for his courage. And the role of the Justice Department's Office of Legal Counsel to provide impartial and independent legal advice for the executive branch. And I've watched that carefully. I came here during the Ford administration. I've always watched OLC do that. The last administration, though, bothered me because they worked to advance extreme theories of executive power. Last week, the department released portions of a November 2nd opinion from John Yoo. It had said FISA only provides a safe harbor for electronic surveillance and cannot restrict the president's ability to engage in warrantless searches that protect national security. It seems an extreme view that we saw during the U and the Bybee era. Will you commit to do a comprehensive review of all OLC opinions currently in effect to make sure that you agree with those that are currently in effect and withdraw some that you don't, that you think are either wrong or problematic?
Senator, I understand that a number of OLC opinions from that period have already been withdrawn, or there's been an indication that they should no longer be relied on the OLC FOIA Reading Room website. I understand also that a process of review is underway.
And you have no problem with that?
I have reviewed the OLC policies and procedures about when they reconsider decisions, how they go through decisions, and I would certainly commit to complying with those policies and procedures about review and of OLC decisions in the past, and I have no problem with that.
Thank you. Thank you, Mr. Chairman.
Thank you, Chairman Leahy. Senator Hatch.
I welcome all three of you to the committee and wish you well. Mr. Verrilli, is your duty actually to defend, as Solicitor General, to defend if a reasonable argument exists or to give advice on that argument or that question?
I think the long-standing tradition of the Department of Justice is to defend statutes so long as there's a reasonable argument to be made in their defense.
Right. Now, in general, is it reasonable to assume that if the Department of Justice has in fact defended a statute, that reasonable arguments exist to support that statute?
I think in analyzing the question of whether reasonable arguments exist, that would certainly be an important consideration.
It certainly would, because the Department is already on record as saying it's reasonable. Would you allow a difference in administration, a Republican administration and a Democrat administration, to decide that issue, or would you decide it based upon the fact that there was a reason to defend the statute of the United States?
I think that the Solicitors General, and if I'm fortunate enough to be confirmed for this position, I would approach that as a question of law, which is how it should be approached. It's a legal question, and the question is whether there are reasonable arguments that can be made in defense of the statute.
Well, let me just say this. You have impressive qualifications and a lot of support. And as I suggested in my opening statement, there are more concerns about the office than about you personally. In fact, I have a high respect for you. I need to know how you understand the Solicitor General's duty to defend the constitutionality of federal statutes, and I want to approach that in a couple of different ways if I can. In Ashcroft versus Free Speech Coalition, the Supreme Court struck down a federal statute banning virtual child pornography. You signed a letter to this committee opposing legislation that would respond to that decision. You expressed grave concerns about the bill and said that it would violate the First Amendment. And as you may know, I introduced that legislation in the 108th Congress, and it was co-sponsored by several members of this committee, including the chairman and ranking member. Both my bill and the conference report passed the Senate unanimously, and in 2008, the Supreme Court voted 7-2 to uphold it. Now, I have two questions. First, do you believe that the arguments in favor of my legislation's constitutionality were reasonable? And second, if you had been Solicitor General at the time, would you have vigorously made such arguments despite personally believing that my legislation was unconstitutional?
Yes, Senator, without reservation. And if I could just say with respect to that letter, if I'm remembering correctly, expressed a revulsion with respect to child pornography, sure, which I deeply feel. And it also expressed support for appropriate and vigorous regulation of child pornography. I think the one thing the letter said was that the legislation on which it was commenting had, at least potentially, a flaw that was the same flaw that had led the previous legislation to be held unconstitutional, and was only making that narrow point. But even having said that, I just want to make absolutely clear that that's certainly a situation in which, had I been Solicitor General, I would have vigorously defended the statute.
Well, thank you. Now, let me ask about this in a different way. Previous Solicitor General nominees have strongly endorsed the duty to defend the constitutionality of federal statutes. When now Justice Elena Kagan was here in February 2009, for example, she said that the only exceptions to this duty were, as you've stated, are when there is literally no reasonable argument that can be made, and when a statute, quote, infringes directly on the powers of the President, unquote. I think you've said that you agree with this description of the Solicitor General's duty.
I think that states that, I think that Justice Kagan stated the standard, yes. Okay.
Now, I'm sure you know Drew Days was the first Solicitor General in the Clinton administration. He appeared before the committee in May of 93 rather. I was the ranking member of the committee at that time and attended the hearing. He said the following, quote, "My understanding is that although the Attorney General or the President can direct that there not be support for acts of Congress, only rare instances would justify that and would have to relate to separation of powers issues." Do you agree with that? I think you've pretty well said you agree with that.
Well, I think that I think I agree that with what General Days said, that the President and the Attorney General, at the end of the day, the Solicitor General works for the Attorney General, who works for the President, and therefore the Attorney General or the President can issue a direction of that kind. I do think that the standards that the Attorney General would apply would be the same traditional long-standing standards that the Department of Justice applies generally. And so I think that the question really would be whether the Attorney General or the President are satisfied that those standards are met. They're going to be very rare instances. They're very difficult cases, but I think that would be the question they'd have to answer.
Thank you. My time is up, but I do have some further questions.
We can continue into a second round once everybody's had their first round, and next in order is Senator Klobuchar.
Thank you very much, Mr. Chairman. Congratulations to all of you. Ms. Seitz, if you are confirmed you're going to be taking over as the head of an office that has gone without a Senate-confirmed leader for 7 years since Jack Goldsmith left in 2004, what would some of your first priorities be if you were confirmed to serve in that position?
Thank you, Senator. The Office of Legal Counsel is primarily a reactive office. That is,
really?
The problems come to it rather than it setting an agenda for resolution of decisions. So I assume that the problems that face the department and the other agencies and the presidency would form the basis for the legal questions, which would then come to me, which would set my agenda for me. Just as a person coming into that situation with an absolutely stellar group of attorney advisors and first-class political and non-political deputies, I think my first step would be to learn from them, and then my second step would be to do my best to give the candid, principled, and independent advice that office is called on to give. But we don't really set an agenda. The country sets the agenda for that office.
Thank you. Ms. O'Donnell, you, the Director of Bureau of Justice Assistance, very important job. And I know that the goal, I know this is a former prosecutor, we worked with your office, but the goal is to create safer communities. And along with administering local grants and training local agents, two components of your job description really stick out to me. The first is the idea of encouraging innovation in programs, and second, creating accountability for projects. As you know, if you've been watching the news, we're in some very vigorous debates about the budget and how we best use the money that we have. Could you talk about how you would focus on making the work of this department as accountable as possible to the public?
Absolutely. Thank you, Senator. As you heard from Senator Schumer, I did have the responsibility of serving as director of an agency that was the criminal justice agency that received BJA funds. So I have a track record and experience for making sure that we are accountable for those funds and consider it a priority to be a careful steward of funds that are entrusted to any agency that I would lead, would I be fortunate enough to be confirmed to head BJA. I think it's important to be fair and be objective in terms of the grant administration process, and to ensure that we build in accountability measures and track the performance of the grants that we are funding. I also think that the role and the course that BJA is really headed on is to ensure that we promote evidence-based practice so that we support programs that have been proven and shown by the data to really work.
I think that's going to be very important as we move forward. I think there's been more and more of that in criminal justice, but there has to be even more because sometimes people just keep going to one program because it's been there a long time. I think it's very important to look at them. So thank you. Mr. Verrilli, I just had one last question here for you. You've argued 12 cases before the Supreme Court. And I know that the Judiciary Committee received a letter on your behalf from almost 80 appellate advocates, folks from across the political spectrum, singing your praises. In part, the letter reads, "The successful functioning of the Solicitor General's office requires an ability to see the effects of particular arguments on the overall interests of the United States, both across agencies and over the long term. Shaping arguments to respect those interests and to protect the special credibility the office has acquired over the decades of its existence while maintaining clarity and force in presentations demands the whole range of knowledge, intelligence, judgment, and other capacities that Don has in abundance." That's pretty nice. That's not my question, though. My question is, in the part of the letter that interests me, it says that how important it is to protect the special credibility the office has acquired over the decades of its existence. How do you intend to do that?
I intend to do that by following in the footsteps, if I'm confirmed, of the great Solicitors General we've had in my lifetime as a lawyer, and the way in which they have distinguished themselves is by acting with integrity, acting with independence, calling them as they see them, essentially, and understanding that they have an obligation to all three branches of government, that they have an obligation to the rule of law, and that I would, if I'm confirmed, do my best to live up to those standards.
Thank you very much.
Senator Lee.
Thanks to all three of you for being here today. It's an honor to be here with you. Mr. Verrilli, I just had a few questions for you. Do you believe that it's the duty of the Solicitor General to advance the political agenda of the President?
No, Senator, I don't think. I think the duty of the Solicitor General is to advance the long-term institutional interests of the United States, and it's not a partisan job.
So it's possible that those two things can conflict, the political agenda of the President on the one hand and the legal obligation to the United States on the other?
Well, I think it's partisan considerations really should play no role in the judgment that a Solicitor General makes.
Okay. And it should be based on your understanding of the law, your ability to convey arguments to the Supreme Court based on the law, based on the Constitution, and so forth. Is that
certainly?
If, as I understand it correctly, Attorney General Holder sent a letter to House Speaker Boehner explaining the decision no longer to defend DOMA. And in that letter, Attorney General Holder explained as follows. He said, previously the administration has defended Section 3 of DOMA in jurisdictions where circuit courts have already held that classifications based on sexual orientation are subject to rational basis review. And it has advanced arguments to defend DOMA Section 3 under the binding standard that has applied in those cases. So he acknowledged that Department of Justice attorneys had defended DOMA Section 3 on that basis, on the basis that rational basis review would apply. Is that your understanding as well?
I have read the letter. I think that is what it says.
Okay. And then the letter goes on to explain why he believes that that's not the appropriate standard, that heightened scrutiny ought to apply rather than rational basis. He goes on also to conclude that there's no reasonable argument that can be made to defend DOMA Section 3 under the rational basis standard or otherwise. So my question for you is, if the Department of Justice has defended a law that it later determines to have been so unconstitutional that no reasonable argument can be made in defense of it, does that mean that the Department of Justice attorneys who previously defended that law acted unreasonably?
No, Senator, I don't think so. I mean, these are quite rare circumstances, but they do arise, and they really have arisen in most administrations. There's an example that when Paul Clement, who was a superb Solicitor General, was here for his confirmation hearing, he described a case involving a law that this body had enacted which had prohibited bus advertisements favoring the legalization of marijuana for transit systems that had received federal funds. And that was a case that the Department of Justice had defended in the trial courts. There was a constitutional challenge to it, and the Department of Justice defended it in the trial courts, did its best. And as he explained to this committee, that when he looked at it, he just made a judgment that applying the traditional standards, that you just couldn't mount a reasonable constitutional defense for it, and so he changed. And I don't think that implies anything about the judgment of the lawyers who had previously handled the case. And I think these things are really tough, and people make the best decisions they can. They apply the standards, they act in good faith, they take it seriously, they wrestle with it, and they do their best. So I don't think it implies anything one way or another about the reasonableness of the prior judgment.
Although here they're disagreeing not only as to the ultimate outcome, as to constitutionality, but as to the standard that should apply. And they're arguing that no reasonable argument could be made that rational basis scrutiny would govern. That does seem to me to require a certain conclusion as a condition precedent to this decision not to defend it, that those Department of Justice lawyers who previously defended it acted unreasonably in their defense of DOMA.
Well, because I was recused, all I really know is what's in the letter. Having said that, I still don't think that I don't think I would reach that conclusion, because these are tough decisions and people act in the best of faith and they make judgments that they think are reasonable.
Sure, sure. And they sometimes make policy judgments. And it appears to me that this was a policy judgment made by this administration, that although previous administrations had defended the law, the Clinton administration, given that President Clinton signed it into law, the Bush administration, and even the Obama administration had defended it, that for policy reasons it was no longer going to defend it. But do you believe that a change in policy, in a political calculation-based policy decision should affect the way the Solicitor General operates in deciding when, whether, and under what circumstances to defend a law?
So with respect to this decision, because the DOMA decision, because I was recused, as I said, all I can say about it is based on having worked with the Attorney General and having worked for this President. And I do have confidence, Senator, that they wrestled with it, understood it was a rare circumstance and a grave decision, and made the best judgment they could on the law. And I think if I were confirmed as Solicitor General, I can assure you that decisions I make will be made on the law and not on partisan considerations.
Senator Franken.
Thank you, Mr. Chairman. Ms. O'Donnell, for the past two Congresses, I've worked with Ranking Member Grassley and with Chairman Lay to introduce and pass legislation to eliminate our nation's rape kit backlog. As I'm sure you know from your work in New York, there are thousands of untested rape kits in crime labs and police departments all around the country, and victims are suffering because of it, and there are new victims because of the backlog. As part of the government's economic recovery efforts, BJA awarded 12 grants to enhance forensic and crime scene investigations, 3 of which went to local governments in Minnesota. The BJA is also promoting the National Institute of Justice's new initiative on sexual assault kit evidence, which will identify solutions to the nationwide problem of untested evidence. If you are confirmed, what will you do to ensure that BJA continues to coordinate and collaborate its work with other bureaus to work toward the goal of testing every evidence kit in this country?
Well, thank you, Senator. I did have the responsibility to oversee the DNA data bank in New York in my prior position. I know how important DNA is to solving crime, and particularly cases of sexual assault, as you point out. So I would certainly make this an important priority at BJA, were I fortunate enough to be confirmed. I know also that other OJP components, particularly NIJ, has taken the lead in this area as well. And I think it's important that the different components collaborate and work together to try to support important initiatives like that.
Ms. Seitz, your amicus brief in Grutter, is that the?
Yes.
V. Bollinger, on behalf of former Pentagon officials, received a lot of attention in that case. Can you tell us about that brief and about the position of those Pentagon officials?
In that brief, we sought to make a contribution to the litigation in the Supreme Court of the question whether the affirmative action programs in place at the University of Michigan undergrad and in the law school were constitutional. One of the questions that might be helpful was the extent to which diversity was an important consideration in both admission to the military academies and in the constitution of the officer corps of the military branches of the United States government. And so we, on behalf of a very prominent group of military officials, went to them and asked for their perspective on this, as well as doing research into the policies at the various military academies, and drafted a brief that was essentially descriptive of their views that diversity in the officer corps and diversity among those being trained for the officer corps was critically important. And so on their behalf, we simply presented that description of the interests of those military officers in that case, and that was an important consideration to the court in resolving the matter.
And so my impression is that the court agreed with your arguments in the brief. Is that correct?
In those cases, there were actually 2 cases, and what the court found was that the policy at the undergraduate admissions was not constitutional, and the policy in the admissions process in the law school was constitutional, and so there was sort of a division of opinion with respect to the constitutionality.
Thank you. Mr. Verrilli, if you are confirmed for this position, you will be responsible for coordinating the defense of the Affordable Care Act in our nation's courts. That's an important job, and while I feel comfortable the statute is constitutional, it's also a tough job. Tell me, why do you want to do this job?
Well, it was really so that I could get a chance to testify here today in front of this committee.
That's a sufficient answer. Thank you.
It's because it would be an extraordinary honor and privilege to represent the United States in front of the Supreme Court. I can't think of anything that, as a person who loves this country and who loves being a lawyer, could want to have more than the opportunity to serve in this role.
I think that's a better answer. Chairman. Senator Blumenthal.
Thank you, Mr. Chairman. I'd like to ask Ms. O'Donnell, this morning for about 2.5 hours, this committee heard testimony from the director of the FBI, and one of the points he made was the importance of resources. In fact, he said that the cuts that are contemplated under one of the budgets that's before the Congress now would prevent him from filling about 1,100 positions in the FBI, which would stall and severely undermine efforts to enforce the law. So resources matter. Cuts in the federal budget have consequences, not only to the Department of Justice, but also to many of the state and local agencies with whom you will be working if you are confirmed. So I wonder if you could perhaps give us your views based not only on your nomination for this position in the Department of Justice, but also as a line attorney in the Department of Justice, as an assistant United States attorney, and as United States attorney in the Western District of New York, as to the importance of resources in enforcing the law.
Thank you, Senator. Well, it's clear that law enforcement can't do it without the resources to get the job done. And I think it's important that we provide the kind of support that our law enforcement officers need. On the state and local side, I would say that pretty much everything innovative being done by law enforcement in most of the states is done because of funding received from BJA, and in particular, the Byrne Grant funding. It funds innovative programs, it funds drug courts, it funds bulletproof vests, like we said, it funds important intelligence sharing capabilities, and those funds are really critical to all of our state and local and tribal partners. So we need the resources on the federal side to support our federal agencies, and our state and local law enforcement officers who are on the front lines fighting crime every day really require that we support their efforts.
Thank you. And Mr. Verley, as you've heard, there's been a lot of interest in when, if at all, you would decline to pursue a case because you thought there was no reasonable argument that could be made for the position of the United States, and you've referred to it as rare that you would reach that conclusion. And I assume by rare, you don't just mean rare in the sense that we as lawyers rarely argue before the United States Supreme Court, or we rarely take a trip around the world. It would be almost a unique situation that would cause you to reach that conclusion. Is that correct?
Yes, definitely, Senator. These are really grave decisions, and they should be undertaken only with a deep sense of the gravity and a deep sense of the responsibility and the strong presumption of constitutionality that every enactment of this body has.
In fact, in seeking to uphold statutes, lawyers begin, if they represent either a state or the United States, with the argument that every statute that is passed by this legislative body, which represents the people of the United States, is entitled to a presumption of constitutionality. Is that so?
That's absolutely right, Senator.
And that's the approach you would take as Solicitor General of the United States?
Yes, it's what I believe.
Thank you.
It would now ordinarily be Senator Sessions' turn, but he has graciously yielded to Senator Hatch, so I will turn to Senator Hatch and then Senator Sessions.
I have to get back to the office. I want to tell you two women that I think you're both very, very competent and good people. I had some questions for you, but I'm not going to ask them. I intend to support both of you and wish you the very best in your position. And I just want to finish with Mr. Verley for a minute. Now, I acknowledge and realize that you weren't in a decision-making role with regard to the DOMA matter, and that it's been made, and that this should not fall in your lap. But with respect, I need a simple and clear answer to this, and I think others will need this. If you believe that reasonable arguments exist to defend a statute's constitutionality, but the Attorney General or President says otherwise, or say otherwise, will you defend the statutes or not? Or resign?
Senator, I would defend the statute unless instructed by my superior not to do so.
Well, see, that's not a good answer. The Solicitor General has the obligation of defending the statute under those two conditions. And I added or resign, not to get you out of the Solicitor General's office, but to give you a reasonable out if you disagree with the President and or the Attorney General on something as monumental as many think this issue is, or a similar issue. So I'm just asking you, would you allow the President of the United States or the Attorney General of the United States to dictate to you as Solicitor General what you've got to do, even though you know it's wrong, under the rules and law?
Well, Senator, the Solicitor General...
You have the right to resign, but...
Yes, Senator. But the Attorney General was given the authority by Congress and has delegated that to the Solicitor General, and the Solicitor General is exercising the Attorney General's authority.
No, the Solicitor General is exercising authority for our country.
Yes, absolutely. Absolutely.
Irrespective of the Attorney General. And if you disagreed with the Attorney General, that, let's just say if you disagree with the Attorney General, you have two choices, and you believe there is a reasonable reason for bringing the case, or it doesn't involve the separation of powers, which are the two categories, then it looks to me like the only choice you have, if the Attorney General insists on making you do something you disagree with, the only choice you'd have would be to resign.
Well, I think resignation would be a very weighty step.
Right.
I don't think, Senator, that disagreement is the standard for resignation.
We're not just talking about disagreement. We're talking about disagreement on principles that have long been established in the Justice Department over whether or not the Justice Department should act on behalf of the Congress, behalf of the statute duly passed by the Congress of the United States. This is important to us. We really believe when we pass statutes up here, even when I'm in the minority, those statutes ought to be defended by the Justice Department unless you cannot find any reason to defend them, or they infringe on the power of the President.
Yes, Senator, and I think those standards are the correct standards.
Well, then if they are, why would you not resign if you were told to do something that you did not believe was right?
Well, I think, Senator, it's just...
I'm not trying to get you to resign.
Yeah.
I'm trying to get you in there as Solicitor General.
I'm just trying to give you my best honest answer here. I think resignation is a very weighty step, and it's something that I just find impossible to answer in the abstract. And I think the answer is, are there circumstances in which I would feel that integrity and principle require me to resign? Certainly, yes. But is that every disagreement?
No.
No, and so it's somewhere...
I'm talking about these two principles that you articulate are the principles. And I'm also talking about the fact that the Solicitor General is there for a real reason. And if somebody politically tries to get you to do something that is not right, no matter if it's the Attorney General or the President, you have an obligation to stand up for what's right, at least as you view it.
I've done my best to answer you, Senator. I do think there are circumstances in which integrity and principle would compel
and there are
to decide to resign.
circumstances where you would resign if that conflict occurred.
Certainly, I can't, as I said, it's very, very hard to answer in the abstract, but certainly there are circumstances.
I think it's just, if you disagree with them, and it's a weighty issue, and the case for the congressional statute meets those two requisites, does not, fits the standards that you've discussed here, then it seems to me you have no choice. Rather than acting politically, you have no choice but to resign. And I think that's a fair question. Like I say, I'm not trying to get you to resign in advance on anything. I just want you to understand that it's that important. That the Solicitor General's office never be politicized in any way, shape, or form. And that you live up to those two standards as a reason for defending. Look, forget DOMA. That's important to a lot of us up here, but this is the Congress of the United States. We pass statutes that we believe are constitutional. Even if you don't believe that the statute is constitutional, if there is a reasonable basis for arguing that it is, and if it doesn't infringe on the President's separation of powers, then it seems to me you have an obligation to go forward and defend that statute on behalf of us up here, on behalf of the Congress of the United States, one of the separated powers.
Those are the standards. I believe in them.
And you live up to them?
And I intend to live up to them if I am confirmed.
Well, okay. I just want you to know I have deep respect for you. We may disagree philosophically. I could care less with regard to your nomination. I want to support your nomination. And you can differ with me and still have my support because of your abilities and your capacities. But these are really important questions. And frankly, a lot of us are very upset that it looks like the Attorney General of the United States, who I supported, by the way, has played a political card rather than a legal card at the request of the presidency of the President of the United States. And that shouldn't happen in the Department of Justice. We all rely on the Department of Justice to do what's right, more than, I think, any other department. And members of Congress rely on the department to sustain our statutes that we go through all kinds of pain to get through the Congress and not be vetoed by the President. So I just raise these issues because they are important issues, and like I say, I have great respect for you. You have a tremendous background, a tremendous experience. There's no question you're a tremendous lawyer. And I respect both you and your wife. And I just wanted to make sure that we understand these issues as well as we can. And I'd feel better if you'd say, yeah, I'd resign before I do something I know is wrong. I think you are saying that, but I'd like to hear it.
Well, Senator, I do believe that there could be circumstances in which integrity and principle would compel me to resign.
That's all I'm asking. That's all I'm asking, and I don't want you to resign. I want you to fulfill
Not
this.
there yet.
Well, I'm trying to get you there, but you're not cooperating. You're being rebellious. Is all I can say. No, I just.
That's the independence you're looking for, Chairman.
That's right. Well, God bless you, and I'm very much supportive of you two women as well, and hope that you'll do a very, very good job that will be apolitical in nature, and that will carry on the duties of the Justice Department in your respective positions.
Senator Sessions.
I share Senator Hatch's views very, very deeply, and am very troubled by this White House and the Attorney General in failing to defend DOMA, the Defense of Marriage Act. It's unacceptable. It cannot be justified. It was direct interference politically by the President of the United States, who during the campaign said he accepted and supported this act. To say that act is indefensible constitutionally cannot be justified. There, 2 district courts have upheld it in Washington and Florida. 5 federal courts have dismissed challenges to this act. 2 district courts have found it unconstitutional. But to say it can't be defended is not correct. And would you not agree that in terms of all the people in the Department of Justice, the Solicitor General is the person that often called the 10th Justice of the Supreme Court, the one that has to stand firmest to defend the rule of law?
Yes, I absolutely agree with that, Senator.
And so, I think Senator Hatch's question about resignation is not a light matter. In other words, I would suggest what should have happened. Solicitor General should have told the Attorney General, we cannot not defend that statute. It does not comply with the law. And the Attorney General should have told the President, I know you may have changed your mind, Mr. President, but this is a statutory law passed by the Congress of the United States. It's been upheld constitutionally, and it has to be defended. We cannot fail to defend that statute. And then what happens? I think what happens is the President says, well, okay, I wish you could. You sure you can't? No, we can't, Mr. President. You cannot take that position. And I think he would have backed off. If not, then you'd have to resign. And that's the way the system works on a big issue like this, because this is politics. And I went through the matter with now Justice Kagan, and I have to tell you that she took an oath before our committee when she was confirmed as Solicitor General to defend this statute. Specifically, she was asked, would she defend this statute? And she said yes. And in my view, this is after looking at it very closely, in my view, Solicitor General Kagan systematically worked with the lawyers attacking that statute to handle the appeals and the challenges to it in a way that furthered the goals of the ACLU who were challenging it and basically failed to aggressively defend the statute. So I would ask you this question. Not only should not, as a matter of integrity, the Solicitor General defend the lawful statutes of Congress, those if they have a basis to be defended within the standards as you've articulated them, but don't you have a duty to not in any way undermine the defense of those statutes? Take any action that would weaken the defense of those statutes in court.
Senator, let me...
I'm not asking you to agree with me about Justice Kagan. I'm just saying, as a matter of duty, if you share that word and the responsibilities it entails, that your duty includes not only defending it in court, but also taking no action that would weaken the defense of the statute.
Senator, with respect to DOMA, of course, I was recused and therefore didn't play any role in any of the litigation, not merely the decision not to defend, but any of the litigation leading up to it. So not in a position to comment with any particularity about the way the defense was conducted. But going forward, Senator, if I'm confirmed for this position, I would, of course, understand that the duty of the Solicitor General would be to defend those statutes that must be defended, and to do so vigorously, and to do so in a manner that does not undermine the defense of the statutes.
Well, I think that's accurate. Mr. Chairman, my time is up, and I would just conclude to say, to me, this is one of the more dispiriting things I've seen. I spent 15 years in the Department of Justice. My view was that a Solicitor General would never participate in what this Department Solicitor General has participated in, the failure to defend a perfectly defensible statute. Maybe people can disagree about its constitutionality, but not that it's defensible or not. And I supported Attorney General Holder and tried not to be a carping critic any more than necessary. But this one really hit me hard, and I think it goes to the integrity of the department. And if you attain this position, you've got to be prepared to say no. And if you do, the politicians normally come around. You don't have to do it publicly. You just tell them, Mr. President, you cannot do that. Mr. Attorney General, I cannot argue that way. You cannot do it. It's wrong. And usually they'll back down if you will stand firm.
Indeed, it would appear that Assistant Attorney General Comey did exactly that in the previous administration, and I think reflected great credit on the department in doing so. But the situation that we're presented with here is that the decision has already been made. It was made without Mr. Verrilli's participation. By the time he is confirmed, if he is confirmed, it will be behind the department. It is not the Solicitor General's responsibility to go back and relitigate prior decisions that have been made. And I think that whatever our disagreements may be about the DOMA statute, it is not, blame is not ascribable to Mr. Verrilli in any portion, nor is this a decision that will be before him in his career, because it has already been made. This decision has been taken.
I'm trying to determine whether or not in the next time another political interference in the rule of law occurs, pushed by the President of the United States or the Attorney General, whether this man will say no or not. That's what we're asking. And I think I love the Department of Justice. I believe in the in the rule of law, and I just got to say, I sat here through attack after attack after attack because the Attorney General fired some United States attorneys to put somebody else in, and was accused of demeaning the integrity of the Department of Justice. And I think it was normal kind of things that occur in appointment processes. But this goes to the integrity of the department, the core of the integrity of the department. At the highest levels, it's unacceptable. And I hope if you're confirmed, you will have learned from this experience. And if you stand firm, usually they'll back down.
Thank you, Senator. I appreciate the advice very much.
Let me conclude with, I've left myself a little bit out of the questioning because I'm, by virtue of chairing, I'm always the last one here, so easier to let other people go and wrap up. I just have a few points and questions.